All right, everybody. Let's give you 1 minute to finish up your conversations and we'll get started.
What's wrong?
Okay. All right, welcome everybody. My name's Greg Balomo. I'll be facilitating tonight. We're here tonight to review colloquially Rule Packet 3. That's Rule Packet 17-06-26-03. So we'll do introductions here in a moment. I'd like to ask all of you on the phone, if you could please mute until it is time for you to speak. That'll make it easier for everybody in the room, and then similarly, everybody in the room, if you can keep the crosstalk and paper shuffling to a minimum, it'll be easier for the people on the phone to hear. Okay. All right. So I'm going to ask Director Wester to give us some words of welcome, and then we'll just jump right in.
Good evening, everyone. My name is Mark Wester. I'm the Director of the Office of Community Access and Independence, and I'd like to welcome you all. Again, this is our third stakeholder engagement meeting this month, and so we're excited to be able to walk through, I think, Rule Packet 3, which is, we're anticipating that it will be introduced to the State Board sometime in May. So at the May board meeting, assuming everything goes as planned. So welcome. Want everyone to feel comfortable. If you need anything, the restrooms are right out here around the corner from the elevators. And so just feel free to step out if you need to. And welcome. So turn it back over to Greg.
Thanks, Mark. All right, just a few words of background, same as the last couple meetings here. House Bill 17-1284 creates a requirement for certain employers to request a check of the APS data system prior to hiring somebody who will be providing direct care to at-risk adults. That will begin on January 1st, 2018. Similarly, it requires that the Colorado Department of Human Services promulgate rules to implement that legislation. So one rule packet has been presented already to the State Human Services Board. The next packets will be shared with them on April 6th and May 4th, the next two meetings. And the purpose of today is to gather feedback to adjust the drafts. Okay? So what we're trying to do is gather actionable feedback on that rule packet number 3. As we said, it's set for review on Friday, May 4th, like Mark indicated. So what we'll do tonight, just a few minutes of opening, then we'll go into introductions. I'd ask everybody to introduce themselves. Then we'll spend the bulk of the time walking through the rule packet, like we have in the last few meetings, gathering your feedback on the portions of the rule that have been inserted, changed, etc. And then we'll take 10 minutes at the end for any last questions. All right. So a few ground rules, same as each of these meetings. I'll manage the session, so if you'd like to speak, just signal. If you could, please demonstrate your respect by doing 4 things. Silence your mobile device. Be as succinct as you can. We probably have 15 people in the room and between 5 and 10 on the phone, so number of opinions. We'd like to make sure everybody gets some air. So that's another way of saying make room for everybody to participate. And we'd like you to consider varying opinions. So as you hear something, let's seek to understand. This is a good environment for asking questions, and we encourage you to do so. Last, we will pause at certain points to ensure that the feedback is captured. As many of you saw in the last meeting back on the 13th, PEG will be actually capturing your requested edits directly into the document, and sometimes that takes a little bit of time. So we want to make sure we get that in a complete, thorough fashion. So at points we may just pause to allow that process to happen. If you have any concerns, please raise them to me. Okay? This is always tricky when you have large groups and you have a telephone, and you're trying to conduct a single meeting. So, here are some guidelines. Please have a little patience with the technology. I'd ask everybody to repeat their name each time you speak, for the benefit of those on the phone, and similarly, those of you on the phone for the benefit of those in the room. If you're in the room, please limit the crosstalk, and I'll make a point of making room for people on the phone to participate. We appreciate your help with that. And if you're on the phone or joining via webinar, please signal your desire to speak in one of two ways, either by interjecting or we have a couple of people monitoring the meeting application, so you can raise your hand in that meeting application, and we'll call on you there. And we've mentioned this before, but this is very important. If you're not speaking and you're on the phone, please mute. Okay? Any questions on the participation guidelines? Give you guys a solid A last time for following those, so thank you. Okie doke, we'll go ahead and do a round of introductions. Maureen, if we could start with you, and then we'll just work our way clockwise.
Sure. My name is Maureen Welch. I live in Arapahoe County, and I'm a mother of a 10-year-old who's in services. He has Down syndrome, and I consider myself a human rights activist.
Thanks, Maureen. Jim?
My name is Jim Tatton, and I'm here to learn more about the rulemaking process and the subject matter of the rules.
Thank you, Jim. David?
My name is David Owen. I'm a family advocate.
Good evening. My name is Amber Burkhart. I'm a policy analyst at the Colorado Hospital Association.
I'm Tawny Couch. I am also a parent of a special needs individual who's an adult, and I live in Douglas County.
My name is Rob Hernandez, and one of the things that I want to be watchful, and I think we should all be watchful for, is making sure that as these rules are designed, discussed, implemented, that we're not violating civil rights of individuals that will be affected by these rules. In other words, let's be cautious about unintended consequences.
Thanks, Rob. Tara?
Tara Frank, I'm the Program Assistant for Aging and Adult Services here at CDHS.
Rose Campbell, I work at the Office of Community Access and Independence, and I am also a co-guardian of a sibling adult at risk.
I'm Karen Campbell, and I am a program specialist here with the Department of Human Services.
I'm Stephanie Nord. I'm a program specialist with APS as well.
Ann Meyer. I work at Disability Law Colorado, and I'm the State Long-Term Care Ombudsman.
Eric Johnson, Deputy Director of the Office of Community Access and Independence, which oversees adult protective services.
Nicole Cosway with the Alzheimer's Association.
I'm Mindy Kemp with CDHS Division of Aging and Adult Services.
I'm Peg Rogers. I'm the APS manager here at CDHS.
All right. Those of you on the phone, if you'd like to announce your presence, you're welcome to do so.
Cristiano Sosa from the ARC of Colorado.
Welcome, Cristiano.
Michelle Reese from the Department of Public Health and Environment.
Hey, Michelle.
Ellen Cruz, Cell Home Care Association, Colorado.
Thanks, Ellen.
Deborah Lively, Litigation, Colorado.
Welcome, Deborah.
I couldn't hear who she was.
With who?
Leading Age.
Oh, Leading Age.
Anyone else on the phone? Seems about right. Okey-doke. If you'll allow us just 1 minute, I'm recognizing that the people in the back of the room, we don't have those pendants today, so I'm going to move the main speakerphone back a bit.
These are outside ones.
Okey-doke. Well, thanks and welcome. Here's what we're here to do. Rule packet number 3 is in draft form. So what we'd like to do is review the proposed changes focusing on new insertions, those are the areas in all caps, or any rule deletions, any places where we had struck through text. So we'll work through those changes, and then if there is need to bounce around the document for clarification around what certain things mean, then we'll go ahead and do that. Okay? Any questions before we begin? All right. Then Peg, if you could please bounce over to the draft rules. Okay.
Can I ask a question? Sure. Are we going over the regulatory analysis piece, or are we just going right to the rules?
I propose we go right to the rules themselves. The regulatory analysis is there just for explanation of what changes are made in the document.
Maybe we can get back to them, because I think they're missing some things in them.
Okay.
We put that in the parking lot.
Absolutely. All right. So for those of you following along at home, we're past the analysis pages, and you'll see that at the bottom of the document, it reads Rules Page X. We're on the bottom of Rules Page 2, and I'll just give you little triggers to highlight where we are. It reads Direct Care, comma, pursuant to section. Okay. Give everybody a chance to read that, offer any feedback, or ask questions.
We have a different rule package. Do you have that? Yeah, maybe it's an earlier version.
Anybody need the most current version? Okay. Okay. Yeah, go ahead, Rob.
When it says, or any, this is Rob Hernandez, or any other service necessary for the at-risk adult's health, safety, and welfare, does that include transportation? Is that intended to include transportation as well? Which would include RTD bus drivers, Access-a-Ride, anybody who does private transportation. Is that intended to include that? Because they would have contact with an at-risk adult.
Mindy?
This is Mindy Kemp. Can those on the phone hear me?
They're all muted.
Well,
Yeah, you can hear. I can hear you.
Okay, yell if you can't hear us, because we have a little bit of a speaker issue in the room. That's a great question. Direct care is part of the definition of who the checks need to be conducted on. But when we get to a later section, it shows the specific organizations that are required to do the checks. I believe that's A under 960. And so those are the only organizations that are allowed and required to do the checks. So under the CBPHE regulations, several HCPF regulations, etc. So RTD and others would be outside of those, so they wouldn't be required to do the checks. So it's only organizations that are covered under those statutes that would be required to do the checks. Direct care is a further, if you will, subset of that. So again, within those organizations, it's not every single employee. It's those that are doing direct care per this definition. Does that make sense?
Why don't we stick with Rob and then we'll come to you, Maureen?
I would think logic would sort of tell me that you would at least want to make sure that Access-a-Ride bus drivers, because they have direct contact with at-risk adults, people with intellectual developmental disabilities, and at-risk adults on a daily basis. So, are you exempting them?
So we're not making any decision on that. This is what's in the statute. So it's what's in the law. So we can't further expand the groups that are required to do the checks beyond what's in the statute. But I do know, that is definitely a consideration, in future years, if legislators wanted to, they could potentially expand this, and it is a good point that this doesn't include every single population. So I think part of the intent when legislators were drafting this is we need to start somewhere, and maybe we can't include everyone and everything that would possibly be covered by this, but I think part of their intent was to kind of make it pretty clear to start with, and then potentially see where it goes from there.
And just one more thing, one more follow-up. So then maybe we need to be more clear on what any other service necessary actually means. Because it's a little vague at this point.
Mindy, this is straight out of the statute, right?
Right, so this is another
Okay.
one of those, this is the definition that's in statute, and so we can't further expand or contract
Okay.
that.
In many of these cases, particularly when you see the citation, it means it's lifted directly from and quoting the statute.
Thanks, Mark. But if you do have questions about whether that is or isn't true at a later section, we'll go ahead and verify. Maureen, did you want to add something on that?
Yeah, I just had 2 questions because I think that facilities operated by a state department, that would include Department of Education for school districts. I used to teach 18 to 21-year-olds in school districts, and they also are treated in day program settings for individuals that can't handle a school setting. So my question is, would that expand to cover those populations that are serviced in school districts or through funding? For example, there's private placements at the Joshua School, which are paid for with public monies, or Firefly. There's other private entities that operate schools for 18 to 21-year-olds. It is a State Department funded position. So
are you asking if those are included?
As a facility, I'm looking on page 9. I don't know if it's page 9, but the list of facilities that are covered by this law, and it says operated by State Department. So Colorado Department of Education is a state department. So yeah, it's page 9 that has the list of who is covered.
Page 8 in the new version.
Oh, sorry.
That's okay.
Oh, the wrong one. All my notes are on the old version, so I'm going to be confused. Sure.
So are we on A?
Yeah.
Just scroll up a little bit.
Yeah, for those of you on the phone, in order to address the question raised by Maureen, we've gone to about the midpoint on rules page 8, where it specifies which organizations fall under this requirement.
So to clarify again, this section is directly from the statute, and so the organizations that are listed here are the ones that are required by statute to conduct these checks. So anything that's not covered under one of these statutes would not be required and would actually not be able to conduct the CAPS checks per the statute.
Okay, number 7 is what I'm looking at. Facilities provided, or facilities operated by the State Department for the care and treatment of people with mental illness. That would be a day program that's provided by a school district.
Those would be the mental health institutes.
Yeah, so you have to look at Article 65 of Title 27. I'm pretty sure if you scroll down a little bit more. Yeah, we would have to look at 6527, but I'm pretty sure those refer to the mental health constituents.
I'm pulling it up right now. Eric? And this is Eric. That reference to State Department comes from language in the statute, and the State Department they're referring to is the Department of Human Services.
Yep.
And that's true for number 8 as well. That's
the regional center.
All right, then Peg, if you could scroll back then, please, to the bottom of page 2. Okay, actually we bleed over into the top of page 3 now, and it reads, employer means a person, facility, entity, ... Give you a second to read that. Just checking on the phone. No questions on the top of page 3, rules page 3. We haven't had to mute folks, have we? Karen? Okay, great. Okay, Rob Hernandez.
Thank you. Well, just as I'm pulling up the statute, I'm sorry to go back to rules page 2, but I'd like to see the referring statutes. And direct care is really very inclusive of hospitals, community clinics, rehabilitation hospitals, psychiatric hospitals, general hospitals, facilities for persons with intellectual development disabilities, nursing care. I mean, it's quite an extensive list.
And
I guess that's my point. And so ambulatory surgical centers, birthing centers, home care agencies, and other facilities of a like nature, except those wholly owned and operated by any governmental unit or agency. So it's a very, very specific, and what it says, I just wanted to point that out, that's what the referring statute addresses. I think it's good to say, okay, here's the discussion about the referring statute. That's what I like to do. So, just for the record.
That's not the referring statute for direct care, which you asked to go back to. The referring statute for direct care is the APS statute, which is 26-3.1-101.
Is there a way you could pull that up, Peg, for us to see?
Yeah, do you have that for us?
Here, I can show it to you. It's right here.
For people on the webinar, though, it might be nice to see it. Can they see it at home?
It's this one right here. So this is the APS
Okay.
statute definitions.
Yeah, right. Yeah, I guess it would be helpful as if we had another set of, it looks like we're missing this piece.
Yeah.
It just to understand what we're changing and where the authority for the change comes from.
Yep.
It just is good to have that discussion. I guess. I'm not an attorney, but I'm certain Jim would probably like to see that.
All right. Any other questions on the bottom of page 2? How about the top of page 3, the part we were at a moment ago where it reads, employer means a person, facility, entity, ... Maureen?
So if this is Maureen. If a person was caring for an individual with an intellectual disability as a family caregiver and employed through a program-approved service agency, they would be subject to this as an employee, correct?
A PASA employee?
Mm-hmm.
Yes.
That's the way I.
Yep. I just want to clarify that because some people felt like that was excluded from this, and I said everything I've read has indicated that they are included in this.
It's under A, right?
Go back to there.
So for benefit of those on the phone, Maureen's question was around program-approved service agencies or caregivers provided through that are covered by this list.
Right. So if a person is on the substantiated persons, because I'm still going to ride that perpetrator word tonight, if a person gets their name on that, then they will not be able to be employed taking care of their family member, correct? If the PASA decides they don't want to.
So to clarify, starting January 1st, 2019, the agencies listed in A, which includes a PASA, when they're hiring someone to provide direct care, they'll be required to request a check of the CAP system and they'll receive a response whether or not that person was substantiated in an APS case beginning July 1st, 2018. And so it will be up to the employer to make a decision as to whether or not to hire that person.
Okay, and what if they are also the PASA owner? What if they also run the PASA themselves? Because that's allowable under statute.
Then they can decide when they're, I assume that they would at some point incorporate as a organization.
No, PASA is all you need.
Maureen?
Well, for example, there's a lot of people that have their own PASA and they care for their loved one through their PASA. So they would be listed as both an employer and an employee. They'd have a dual role. And they'd be on the registry as both an employer and an employee. I'm just getting clarification on that because there's a lot of people in the community that have asked me to ask, they'd be seen as both the employer and the employee.
Yeah, I guess that would be.
I would imagine so. What if they were also providing the direct care? And if you're talking about like an individual family or individual that develops a PASA and then they provide direct care to their loved one, yeah, I guess you could have the owner also being direct care.
There's several hundred of those in the state. Maybe thousands. I don't know. Last time I heard
there's about roughly 400, a little over 400 PASAs that serve IDD folks in the state.
Right.
According to Healthcare Policy and Finance, I don't know the exact number, but I know
I think it's 498 last time I looked.
So, yeah, so.
Wow.
Okay.
Just pause for us to be able to capture that.
So have you done any, sorry, this is Maureen again, have you talked to HCPF at all about the impacts on the PASA entities with this registry, or has that not kind of been part of your process as a department?
No, we have already been in touch with HCPF and are working with them.
Okay.
Just a reminder, the bill passed, so this is just the rules to implement the bill. It's not, you can't do anything to change the legislation that exists.
Unless we run another bill.
Correct.
Right.
Rob.
On the definition of employee, there seems to be some conflict when you define an employee who may be a contractor, and you're saying that that now somebody who contracts to provide services is now an employee. It seems like that conflicts with labor laws. So if that person is continue to be, let's say their employment is terminated for some reason, that according to the way that I read this, that they can go get unemployment insurance. I see a conflict there with the statutes, but that might be up to an administrative law judge to decide.
Is that language directly from the statute?
I'm surprised that no one in the legislature caught that. There's some super brains in there, so.
Give us a minute here just to record that.
And yeah, if you could cite what the actual citation is from 1284, that would be helpful too.
Okay, I think it should be thought of as ending.
Because there's notation in the previous rule packet, but we don't have that in front of us.
So citation, suggestion to include a specific citation. I don't know the law well enough. Is it not the same citation directly above?
The citation from 1284 was your,
Yes,
not from statute, but from words that link into the bill.
Right, to 1284, yes.
Okay. So it would be per 1284 citation.
I don't know that employee was defined in 1284 because it's not in listed definitions.
But Peg just said it was.
It's defined, it's defined in section 111.
Oh,
They didn't put it in our regular definitions.
So it's
Gotcha.
per, if you look at the, under employer, the first line, 26, 3.1, 111, 7. Or, oh no. No, sorry, these are defined in 111.2. Section 111.2 of the statute.
Okay, so I think in that case the citation might be helpful.
Tara, do you mind going to get some copies for us?
Sure.
Copies of. Yeah.
Jim?
This is Jim Tadden, just a personal observation. Here we are in the rulemaking process, and we're confused with regard to what this language means. We have the experts who drafted it. We have references to statutes. We have references to legislation. My point from the beginning has been these rules have a direct impact on individuals and families. You don't want to make mistakes. And if we're at this point, at this time, arguing and trying to understand what these rules mean or what our authority is to create these definitions, we got a problem. We got a problem. We're fast-tracking legislation, and I think that creates an awful lot of concern for individuals, families, communities, and counties.
Thanks, Jim. Any other comments on the employee-employer portion of this?
Is anyone on the phone?
Any comments from the phone?
Yes.
Hi, who's speaking?
So hi, this is Elizabeth Braun.
Hi, Elizabeth.
I also have an issue with language because I'm a one-person process who hires occasional subcontractors as needed. And it's very clear in my contract with them that they're not employees. They have to get their own everything. And they're not going to get any benefits or workman's comp or anything. And I just this language is not very conducive to me understanding, do I have to do this for every contractor I might have? And if so, are they now going to come back and say they're an employee and do get workman's comp and stuff?
Thanks, Elizabeth. Pick up on that.
No, I think that for questions like that, you're welcome to consult your legal, because that's really an interpretation of the statute, and I don't think it's our role to interpret, what the statute means for your particular circumstances. We've told other stakeholders the same, that for those type of sort of what-if situations, that would probably be helpful.
I think that, hi, this is Maureen. I think that Elizabeth was asking for clarification in this rule language because we're going over the language. I don't think she's asking whether she should ask her attorney. She's saying this language that's up there is not clear to her how this is supposed to be interpreted. To me, that it should be clear in here.
Right. So to clarify, based on this language, it would be my interpretation that you would need to do the CAPS check for someone that you're contracted. It says or contracted with. But in terms of whether or not that person then becomes legally an employee of yours because you've conducted a CAPS check as a requirement of this, that's where I'm talking about. I can't. That's like a legal question. I can't answer that for you.
And just to underscore what Mindy is saying is contractors have very specific standards that they have to meet. And so any organization that utilizes contractors would need to make sure that they were meeting those contractor standards according to employment law. So that's why we're referring you back to, if you have a question about that, that's where you need to get your own legal counsel to see if your contractors meet the definition of contractor, or in fact, because that has been an issue in the last several years within the state of Colorado, is whether or not contractors meet the standard of contractor or they're an actual employee. So.
Well, take it as a given that they are meeting subcontractor standards. Then, how does this read?
That they would be required, you would be required to conduct the CAPS check on them.
And wait
That's
10 days to get it back.
A maximum of 10 days per the draft rules.
Eric?
Which is a really long time when you need some money yesterday.
This is Eric. I just want to also point out that under the statutory language of 26, 3.1, 111, 2, section 2, it says that these definitions of employee and employer are, these are definitions to be used in this section. So what that means is that these are not superseding the definitions of employer and employee that are in labor law. They are to be used just in this particular section of the statute. And that's something that you do see very commonly, that when you may see the same word defined multiple times within the statutes, and there's usually language that says, there's usually language there that'll say that this is only supposed to be used in this particular section of the law. So I just want to clarify that.
Thanks. Rob?
The only thing with that is that I think probably, since there's confusion and there seems to try to prevent any disputations regarding this issue, I think one of the things is that there's two ways to remedy this. One, to go before legislative legal counsel and say, you guys need to clear up as representative legislature what this actually means. You know, what does a contractor mean? And so for us to say yes it does or it doesn't, because it still raises the question that there is a possibility that it is. I mean, it's very clear if you're putting this into rule that an employee means a person who is employed or contracted. There's some confusion around that. And so legislative counsel probably should need to take a close look at that. Or the other remedy is to have the court strike down this particular rule, or have a bill to repeal it. So there's confusion, so we need to have some kind of remedy that clarifies it. So unless the Attorney General had given you that specific ruling, Eric, I'm not sure where that is. It's still confusing.
Eric?
Hi, this is Eric again. I just want to remind people that this definition is in statute. And so it was written by lawyers at the Office of Legislative Legal Services, and presumably, I mean, I have worked with them before.
Yes.
They do go through a process of making sure that they are not creating unintended consequences by putting in a definition like this. And that's, I believe, the point of the language that says, as used in this section, employee means this, employer means that.
Okay. All right.
So, moving on to the confidentiality section.
So moving on to section 30.250. This is about midway through page 5, not thick.
Yeah, so my pages are not the same as yours because I'm adding text, and so it's rolling things
It
to
is
the
starting
pages.
to roll, I got you. But I can confirm it's about 3 inches down on the 228 draft. Rules, page 5. It reads, the disclosure is made for purposes of, and then there's a section, another insertion that reads, disclosure is provided to an employer, ...
Now, the gray was in packet 2, right? Yes, so we're looking for comments on 11.
Any questions on that portion? All right, we'll go to the next 2/3 of the way down, rule page 6, section 30.320, background check requirements. There's about 3 inches of text inserted here. So part A begins pursuant to section 26.3.1-107, section 2 CRS, beginning in.
And I would clarify that this section only pertains to county departments of human services APS programs. This section does not apply to employers.
Thanks, Beck. Okay, this is a pretty good sized block of text, so we'll give you a couple minutes to read this. Maureen?
Yeah, this is Maureen. I guess I have a question. This is all about the county checking on applicants to be an APS employee, correct? How does a person file a abuse, neglect, exploitation claim against someone that already works for the county?
You call the county department and you make a report.
Okay, so is that, what do I want to call it, the same across every county, or does every county have different rules about how you report?
If you're calling to make a report of mistreatment or self-neglect, you call the county department to make that report.
And it can, who investigates an APS investigator?
Another county department.
Another county department? Has that ever happened before?
I cannot answer that question. I cannot share information about APS cases.
I think she was just asking about the process.
Yeah, that is the process.
So the process is secret.
If there is a conflict of interest in a county that receives a report, whether it's about another APS worker or about a family member of an APS worker in that county, then another county does the investigation. The case is marked confidential in our system. No one can see it except the county that's doing the investigation and state staff.
So there's a change in that.
Okay. Yes. Well, it makes sense, but that's not how it works in the CCB world. They investigate themselves, so that's why I was asking. I know it might seem like a silly question to you. Of course, you wouldn't do that, but there are situations in other parts of the state government where people actually investigate themselves.
I understand that,
so,
but we do not.
Okay.
Thanks, Peg. Any other thoughts, questions, or comments on 30.320? Okay, we can always come back to that if you do. Moving on, the next spot I see pegged about in the middle of page 8. This is the large insertion. For those of you following on along at home, this is the middle of rules page 8, 30.960, employer caps checks. This is the bulk of the insertion here, so we'll allow a bit of time for folks to read this. You'll see that the beginning here are the organizations covered and the references that define what each of those means.
To clarify, for those on the phone, this is Mindy Kemp. Again, Section A comes directly from statute. So the language in here is A and then 1 through 9 or whatever it is directly from the statute.
B is actually directly from the statute too.
So are we limiting the initial comment just to the A part, or there's like a whole
No, in fact, I don't know that there can be much comment on the A part as it is lifted directly from statute. So it probably makes more sense beginning in part C. Is that true? Okay.
Well, C again is directly from statute.
Yeah.
Okay. So then, does it begin then at part B?
Well, I have a comment on A, B, and C.
Okay.
I think that this entire thing is ridiculous. I think it all belongs in the trash can. I think that this entire idea of creating a registry in this manner, in a very process lacking the due process, which I know is packet 2, but it's part of the whole process that we're talking about here. I really feel like this entire 1284 implementation is faulty, and I just want to go on record to say that I really feel it needs to be repealed or through a court process stopped, whether that's through a legal process that the community begins or through legislative legal services or through a civil rights lawsuit. This is going to impact the unintended someone brought up unintended impact. I think that
Unintended
was
consequences.
yeah. I mean, this
consequences.
is going to create and this is going back up to 50,000 feet because it relates to these rules. This is creating a culture of fear in the community because if, for example, I taught 18 and 21-year-olds, I already divulged that, and I travel trained them how to ride RTD to get to work, right? Taught them how to ride to work. If something happens on that ride to work, is that parent going to be charged with neglect for letting their individual ride the bus to work because they may not have fantastic judgment? This is the thing. I really feel like the civil rights thing at 50,000 feet is the fear of implementing this registry, which is the bigger piece of Part 3 today, is going to limit the freedom that individuals with disabilities have to live in the community. Because people are going to be so afraid, they're going to be helicoptering, everyone's going to have a paid support person with them in the community, because otherwise they're going to either be charged with exploitation or self-neglect. Oh, they're self-neglecting because they missed lunch. Well, my 20-year-old at Boulder misses lunch all the time. And just because he's neurotypical, I don't get charged with neglect. But if he had Down syndrome, oh, Maureen, then you're neglectful. See, this is where there's a double standard. And it's like we're putting a different expectation on living in the community to people that are at risk, whether they're older, whether they have a brain injury, whether they have an intellectual disability. I'm very concerned about this from a civil rights. Everyone has the right to live in the community. And the way that this registry is being implemented is it's going to impact people where they don't feel like they can do that because they'll lose the ability to be with their child. They will lose the ability to run their PASA and have direct care over their loved ones. And they will feel like they can't speak freely at meetings like this, or at CCB meetings, or in the community, or at their service plan meetings, because they could get charged with exploitation or neglect. This is my concern, and I'd like to hear from other people on the phone. I'm trying to talk loud. This is the fear that I'm hearing from the community, is that it's not really the language, it's not the statute citations, it's the intent of this law to create a culture of hovering and over-protecting individuals that have that at-risk category. That's the concern. We want to live in the community. We want to have community-based services. And that might mean that somebody is in the community without a paid person. And that's not neglect. That's called living. That's called living. And I think my son and everyone with an at-risk label has the right to live in a community of their choice. And if my son wants to live in an apartment and once in a while he forgets to go grocery shopping, hey, my 20-year-old does that in Boulder all the time, but I don't get charged with neglect for him. This is the point. We have a double standard going on here. So I'd like to hear from other people in the room and on the phone about that. Thank you.
Anybody on the phone want to chip in?
This is Tawny Couch. As I said earlier, I'm the parent of a special needs child, an adult child. I also work, for the lack of a better word, in the industry. When you go to your meeting and you're talking to your direct service provider, part of what you have to do as a direct service provider is tell them, the person that you're going to be working with, their rights. And this particular bill, or legislation I should say now, flies in the face of that. And I understand what Maureen is saying. We tell them every day, okay, some of us tell them every day, this is your right. You don't have to do this. Or you can do this if you choose. Here are the consequences of such a decision. We're negating with this type of legislation their humanity. Yes. That we in the United States believe so heavily in. Yes.
Thanks, Tawny. Rob.
And I think the thing that's missing is that when we start discussing and dealing with people who have intellectual and developmental disabilities, every single one of them has chronic conditions. Every single one of them. So sometimes the entry point for medical care is going to be the emergency room. Sometimes it's not. Sometimes it's going to be the clinic. And wait times in this country are horrible. I mean, it's 4 weeks sometimes to get to see a primary care physician, unless you absolutely, unless you go to an urgent care clinic, but not everybody has Kaiser or has an HMO that's going to deal with that. So let's say that a family takes an individual and gets a procedure done, and an APS does an investigation. Well, we disagree with that physician. He shouldn't have done that, and we're therefore, because of preponderance of evidence, we're going to determine that that procedure was neglectful. Well, then you've just now opened up a whole field of healthcare providers that could potentially be on this registry. And having been and having worked at emergency rooms and having been around it, that's concerning. So it troubles me that an APS person with a minimal amount of training is going to be able to go in and say, well, based on a preponderance of evidence, we think that Dr. Smith is guilty of neglect because he used the wrong procedure. Well, what medical school did they go to? So there's some concerns there, not just about how much the fee is going to be, but when you start these types of investigations, and the doctor may not even know that he's been, or the nurse, or the attendant who was around the clinic or the hospitals, may not even know that. And I think Maureen has a case that's going on right now. So there's concerns about this from a very high level on what this is starting to do, how this will affect the culture. There's trouble getting people to provide direct care services on a daily basis to individuals. But when you start looking at this, it's the cost. But I can tell you that, in emergency rooms or clinics or HMOs, they're going to say, wait a minute, we've got this new statute and all of us at Kaiser have to go through this. That's what it says. So there's some concern there. And so that's just at a very high level. And I agree with Maureen. I think this violates more civil rights and perpetrates more harm than it does good.
Mark? Sorry, Mark wanted to go ahead.
Writing on that.
So I would like to add, if someone wants to repeal this legislation, they just need to repeal the legislation. They need to pass legislation to repeal this legislation. That's how we get rid of the bill, the legislation.
Who is this speaking?
This is Ellen Crusoe.
Oh,
but I'm just wanting to say, if you don't like the legislation, you go to the Capitol and change and repeal it. That's how you get rid of it. You don't have a governmental agency change it, or it's not. If you want to get rid of this bill, get rid of the bill. Go to the Capitol and repeal the bill.
That's one remedy.
Thanks, Alan. So, sorry, Mark, you wanted to pick up.
Yeah, I was just going to, I think we're getting off beam of the intent of the rules and the statute in the sense that this is relating to direct care staff who work with at-risk adults in the defined organizations. Doctors, to go back to some of the examples, they have their own license. They also have statutes around abuse neglect that they are responsible to and accountable to DORA. And that can be, in fact, if they were charged with neglect or abuse, it would be reported to DORA. And that would actually automatically notify their health system that they work for. So they're already covered, right? What this is talking about is staff and contractors who provide care to at-risk adults and are found to be substantiated for abuse, neglect, exploitation, or abuse, neglect, mistreatment, I guess. And that's what it's about. It is law at this point, and the Department of Human Services is taking steps that are defined and mandated through the statute and the law to promulgate rules. That's what we're talking about tonight, is the rules promulgated as a result of the law that is in place. Okay, I just want to be clear that by all means, and the woman on the phone was exactly right, in terms of changing statute, that's a legislative branch function. We are currently in the executive branch, and we are implementing the law that was given to us by the Colorado General Assembly last year. Okay? I just want to be clear on kind of what our responsibility is as a department and what the legislature's responsibility is.
Oh, we understand.
Responsibilities and frankly authority, I think, is
Absolutely.
the operative. Jim T.
This is Jim Tedden again. So if I understand the rules and their relationship to the statute, these rules are essentially just recommendations or guidelines or policy from here on out. They're essentially just kind of recommendations.
No, they are the rules, and correct me if I'm wrong, Peg or Mindy, the rules function to describe how the process and the program is going to function.
Wow.
The implementation of the bill.
So they're going to have the full force and effect of law.
Yes.
They're going to be no different than the statute that they're implementing. That's my whole point.
It's rules attached to a law
They have
that
the
is
full-
currently the law of Colorado.
and they will be construed and applied separately from the statute. Maybe in harmony, read in harmony, but they are essentially to suggest that these will not have the full force and effect of law, I think is a mistake. And to suggest that the only way to have a positive impact on individual and families' civil rights is to repeal the statute, to go to the legislature and ask them to repeal it, I think it's a mischaracterization of the rules and regulations that are going to be proposed to the board.
Okay, hang on one second, Mark. I'm sorry, thank you. I just want to bring us back here. Could you take us back to the PowerPoint presentation?
Am I wrong?
No, you're right. That's why there's a rulemaking process. That's why we have the state board. That's why they're appointed by the governor, because this is a check and balance, and we can tell the state board not to implement it and to delay it.
This meeting, and the only authority within the room, right, is to get actionable feedback on this draft rule packet.
Put it in the trash can. That's what I said.
We also suggested you put the law in the trash can, which is not within purview of those here assembled. So, do you have specific actionable feedback on the draft? Because the draft is scheduled for review on May 4th.
No, May 6th. Or no, April 6th is the first reading at the state board.
No.
That's for rule
Oh,
packet 2.
They're not doing the introduction of rule packet 3 on April 6th?
What I stated was that we anticipate rule packet number 3 going to state board in May.
For first reading or second?
First,
Okay. I didn't hear the first and second when you spoke earlier.
Yeah. So the timeline takes the second to last page in the packet here.
Towards the end.
Right there. So, rule package 2 on April 6th, and rule package 3 on May 4th.
Right,
Those are the
originally
next
I
two
believe they were going to do
dates.
first reading on April 6th though, correct, Mark?
No.
No?
Okay. So, bringing us back to our objective for this evening, do we have actionable feedback on the draft rule language? There's a large block of text here, and I don't want to skip over what is, goodness, almost 3 sides of single-space text. So, are there specific issues with really it's 30.960, employer caps checks. Is there specific feedback on that portion?
I think it's illegal. The whole thing. That's all.
Okay. How about from the phone? Any specific feedback on section 30.960?
Cristiano, you're gonna have to apologize. I'm in Greeley, and I don't have access to a computer, so I'm not able to look at the screen.
Okay. So anyone can at any, excuse me for just 1 second, then I'll come back to you. Anybody can at any point submit in writing any recommendations or suggestions related to this as well, and there's plenty of time before that May 4th first reading to embody that. And the correct address for them to use for that by email is mindy.kemp, mindy.kemp@state.co.us. And I'm sorry, I overspoke somebody on the phone. I think it was a female voice. I'm sorry for that. Go ahead.
That's okay. This is Deborah Lively with the Colorado, and I just want clarification that you're going to delete F. Is that correct? The employers have to notify the department if they're no longer employing someone that they did the cap check on. Is that correct?
Hi, Deborah. This is Mindy Kemp. Yes. So we this is the final version, other than any changes we make as a result of tonight. But we are planning on deleting F. And that's based on feedback that we had received from previous stakeholder groups, and we understand that that will be would be a challenge for providers. It would frankly be a challenge on our part to maintain as well. So instead, we're still moving forward with the flag check, which is K on page 10, notification after the initial catch check. However, we'll have an internal process in place to ensure that that person still works at the agency prior to releasing that information.
Okay, thank you.
Mm-hmm.
Thanks, Deborah. Anybody else on the phone, specific comments on 30.960?
I'm sorry, this is Deborah again with the Colorado. Just on the fees, do you have any idea what at this point you're going to start with? I know the maximum is 35 outlined in the rules, but you said that it's probably going to be less than that to start with. Do you have any idea on that yet?
Sure, this is Mindy Kemp again. We are getting that question a lot. We haven't set an exact fee since the checks won't start until January 1st. We're giving ourselves a little bit more time to make sure we're doing all the data analysis on our part. But essentially, the assumptions made in the fiscal note last year still hold true in terms of the numbers that make up the $1,650 was the estimate. We will need to decide internally in the department if we start at, somewhere between $15 and $20 is my guess. So we wouldn't start like at $35 or something like that. And in terms of time frame, once these rules, are finalized, then we'll be finalizing over the summertime is my guess on what the fee will be. And then we'll also be, I know I've heard some requests, we're doing stakeholder outreach because folks have asked, how are we going to know what the website is and where to go and what the, how to plan, what the proposed fee is and that sort of thing. And so we'll be developing sort of a communications toolkit to share information with providers who will be required to do the checks so that we can proactively get information out to you. And of course, working with CDPHE, HECFUF, and other state partners to use their networks of getting the word out. So it will not be a, January 1st hits and it's a surprise thing. We'll be spending some time over the summer really thinking through how we communicate and get the word out about all aspects of this.
Okay, and I appreciate that, and I would just say that, and you've been really good about this, but including all these, relative associations in there as well.
Right. And if you, at any point, if you or others know of somebody that we're missing or who's not in the loop, feel free to let me know personally, and I'll make sure to leave them in.
Okay, thank you.
Follow up on that question. Yeah, I just had a follow up on the question that was just asked about the cost. If there is a greater than projected amount of appeals, because you're covering your cost, you would need to go back to the state board to increase that amount. Is that correct? You're keeping that door available and open to go back to the state board and increase the cost should there be a huge amount of appeals that you're maybe not projecting.
Right. Let me see if I can find the language directly from staff.
It said that you could go back to the board to raise it.
Yeah, I recall reading that. Give me just a second.
Yeah, it's in there somewhere. I didn't highlight it.
It's up here.
So it's the statute, though, is what I want to kind of reference.
Right here. Unless the Board of Human Services approves an increase based on increased directed increased costs, which could be the appeals process. So it's a temporary maximum that could go up.
Right, so what the statute says is that the state board rules must include a provision requiring the State Department to provide notice of the fee and the maximum of fee amount. So basically statute directs the state board to have rules related to the maximum, and then it directs the department to establish the fee. And so the maximum, what we're proposing in this rule packet, is $35. What I'm telling Deborah and others on the phone is that, you know, we're estimating to start the fee between $15 and $20. And so if for some reason there is additional costs, we can raise that fee as a department up to the $35 if the state board approves that as the maximum. But then anything over $35 would have to go to state board. And so we're really hoping, first and foremost, that it isn't $35 and that it doesn't go over $35. But anything over $35 would need state board approval. Does that make sense?
Yeah, just saying it's a temporary maximum. It could go up in the future.
Yep.
That's what I just want the employers to know, that this is not a permanent maximum number. This could go up quite a bit if there's a lot of appeals.
Mark?
And we have actually spent a lot of time meeting with providers and stakeholder groups, including organizations such as Alliance and Hospital Association, those kind of things. But this goes back to something Jim brought up earlier, and that is, that's the function of rules, is that the state board has authority over those, and the department can petition the state board to alter the rules. And it's a way of making the statute as you implement it flexible enough to where if after a while of implementing and with some experience, we recognize, hey, this needs to really be changed, we'll go through the rule change process again, just like the initial rule change.
Yeah,
so.
Connie, did you have a question?
I'm just trying to wrap my head around, as an employer, how I would implement this. And for case of being able to be fluid with an ever-changing, let's back up. Knowing how changeable life can be, dealing with folks who are IDD and a myriad of behaviors. If you are trying to employ the proper ratios of staff to, let's say, throwing it out there, a day program, stepping on the rights of the individual, because they do have quite a few by statute, that the 10-day waiting period could be a real problem. Is there any way to shorten that? If we are stuck with this monster, how do we tame it? And how do we get the monster to perform at a faster rate? Because I'm telling you right now, I can go out and buy a handgun immediately, practically, and it goes through the FBI. Why is this taking so long?
I know that the rules read a maximum of 10 days.
Mm-hmm.
And maybe you said earlier that you don't expect that it will take that much, but if you want to handle Connie's.
Yeah, because having to do CBIs, that's fairly immediate, though flawed. That's flawed. I'm kind of wondering, are you really anticipating 10 days, or is that just to pad and keep?
And what if it went past 10 days?
Yeah.
What's the teeth in that to make the department perform at 10
Right.
days and not exceed 10 days? I don't see any teeth in there.
And honestly, I'm thinking of this as a provider and trying to provide services to someone who has finally decided, you know what, yeah, I'm gonna finally leave the house.
Right.
I feel comfortable enough with this person to go out and do that. Oh crud, I'm waiting.
Right.
And I'm truly afraid that we'll be waiting in limbo for a long time, and parents are not going to. They're going to be like, well, they're not going to understand this.
Right.
They're not going to understand this.
So this is Mindy Kemp for those on the phone, and we have heard that concern from other providers as well. And so the statute, again, permits the department a 10-day maximum turnaround, and so that's what we're reflecting in the rule. However, the way that we're designing the system, we base the 10-day turnaround also on the child welfare rules for the trails checks in that system that have a 10-day turnaround. It's a similar process. We know it's a different population, but it's a process that's similar. However, we are building in some efficiencies to our process that they don't currently have in the child welfare system. So, for example, the employer will be able to go and register online to request the check. And so, currently, the child welfare system, for example, child care agencies that are requesting a check need to mail in a paper form, and so there's like that delay of getting the mail to us and having us open the mail and all of that. And similarly, they receive their response by mail. We still have that option built in here for those who won't choose to request the check that way. But then we'll be designing a system where you can go online and request the check, so it will instantaneously get to us. And then we'll have a staff that's available to do the checks on site here and send you a pretty much automatic response. So we're envisioning that ideally it would take 1 to 2 days and not 10 days. However, since we've never operated a system like this before, and because we don't know how many requests for checks we're going to get, and because the volume could vary, right? We can get one check one day and 1,000 checks the next day. We really don't know. We're suggesting to the state board that they give us the 10-day maximum leeway so that we can be sure that we are in compliance. We take our responsibilities under rule very seriously, and we want to be in compliance. So we want to set up a rule that we know that we can meet, but also really doing the best on our side to be as efficient as possible with those responses. Because we have heard absolutely from providers, we get that there's real concerns with hiring and that delay could be an issue.
And this is Tawny Couch again. I'm really concerned about that January 1st. You guys are I see systems crashing, like all around us.
Right.
How is that, what is the contingency for that? Do we all just stop working because we don't have our caps done?
Yep.
And I'm being very serious here. I mean, what?
So yeah, this is Mindy Kemp again. For those on the phone, the question is around data systems, and I think what you're trying to get at is that will we have the data system up and running and have the capability to do that? And so we have done a very good job, I think, on our part planning for that, working with our vendor. We have an outline in place. We'll be working closely with them to make the changes necessary. And like I said, after these rules are through, we'll be doing further outreach and communication on, here's the link to the website, here's the link, here's the process, here's what you need to fill out.
So will we be able to get to that site prior to January 1st?
Yes.
That is my question. I just have visions of everybody going to the site on the same day at the same time, and there being a small explosion in Denver that we'll all see from Highlands Ranch.
Yep.
And
That's a great question.
that's seriously what and thank you for that. I do appreciate that.
DXC.
That's exactly what I was thinking.
Yeah.
But
I wasn't gonna bring that one up.
Actually, Tani, this is Peg Rogers. The Rule D requires employers to register with our system so that we can check and make sure that they are authorized to request the checks, so that we don't have people who are not authorized doing the checks. The plan is to have that system up and running December 1st, so that everyone can kind of get registered over the course of December, so that when January 1 comes, they don't have to both register and wait for us to verify them and then wait for the check. So that employers can get registered during the month of December, so that January 1, when they need to start doing the checks, they're already in the system and we can just do the check.
Okay, and also to facilitate that, are you going to take the information from, let's just pull one of these entities out, and the PASs, and just plug those in, or are you going to wait for the individuals to come in and do that on their own?
They have to come in and register.
Okay.
But that will be part of the outreach that Mindy had talked about in making sure that we're getting the word out to all of these folks on that list.
Okay.
Mark? This is Mark Wester. Tani, are you I just wanted to ask, are you an employer?
Yes, I am.
Okay. So how long does your background checks now, your criminal background checks take?
Instantaneous.
With CBI?
15 seconds.
Okay.
Yeah,
And
that's slow, right?
Do you check also county court records?
No.
Okay. Because what I was thinking of is that in my experience of operating provider agencies, a lot of times background checks, even with CBI, take a number of days. And then if you check the county court records where people have lived, both inside and outside the state, it often takes you longer to get that information back. If you're not doing that, then there is a gap in your background check process, the criminal background check, because not always do cases get loaded up into CBI from the county. So it's not uncommon for providers to offer jobs contingent upon background checks, and usually that it's very seldom instantaneous. So.
Thanks, Mark. Did I hear somebody on the phone wishing to speak?
Yes, couple of things.
Who's speaking?
One, Elizabeth Braun again.
Thanks, Elizabeth.
And he just said that in the past, employers have employed people contingent upon the background check, meaning that the person got to go to work the next day, but if the background check came in 5 days later, that there was a problem, then they were fired. That's my understanding. Is that not right?
Did you say offered or employed?
Offers are given typically, or an option for a provider is to make a job offer contingent on a background check. And what that often does is it allows them to start them in training, usually in IDD systems, and long-term care training is up to 2 weeks long. And so by the time they're finished with training, they they have the background checks and everything they need. I'm not talking about starting, most employers don't allow, when they provide a contingent job offer, they don't allow the person to be alone with people supported or clientele, and until the background checks are back. And so that's just kind of the mechanics of going through that process. And again, the training that's required by the state
So would that same contingent be allowed for the CAPS then?
Now, the contingent offer is based on what an employer does with a prospective employee.
Right. To clarify, this is Mindy Kemp. The statute does not preclude the employer from hiring somebody. So the statute requires that the employer request the CAPS check before hiring them, but it doesn't say, and then you have to get the results, and then you have to decide whether or not to hire them. So it just requires that the employer request the check, but then the statute actually doesn't say whether or not they cannot hire the person.
Okay, because I was wondering about the contingent part, if that was supply as well. It sounds like it does.
Thanks,
I think he was actually just talking about.
Cristiano from the Arkin, and sometimes that's called provisional as well.
Right.
And you know, I do think it allows some flexibility here, frankly, and I don't know that we would want somebody working with folks without training and understanding the systems and all of that as well.
Okay. I was just wondering about how that works. Thank you very much.
You bet.
Section.
Thanks, Elizabeth. So the portion that we were hoping to gather more feedback on was 30.960. Rules, page 8.
Well, it goes all the way to the end, right?
It does.
960?
Yep.
So I have a major concern with one that's on the last page, page 11, I think, 11. L3. So L says the findings shall not be included in the CAPS check results when, and I'm just going to read it because I know that, like, Cristiano's on the phone and he doesn't have the packet. So it says it should not be included in the CAPS check when, number one, the finding was made prior to July 1, 2018, which makes sense. Number two, the finding was expunged as the result of a successful appeal, which I believe could take up to 18 months after the last time we computed it. And then number three is the substantiated perpetrator was 10 years or younger at the time the mistreatment occurred. So is this saying that a person as young as 11 years old could be put on this registry?
Mm-hmm.
That's a major concern. Now we're talking about minors being put onto something that's a blacklist. This is extremely concerning for me.
We'll make a note of that, thanks.
Yeah, is that in the statute somewhere? What is this?
So
It says up there. It says the substantiated perpetrators outlined in section 30.910. Is that part of that quote?
No, that's where the July 1st comes from. But so this particular piece comes from the child welfare.
It's the age of culpability.
Right.
Age of culpability for preponderance of evidence. I can't speak tonight. So there is an age of, what did you call it?
Culpability.
Culpability for something that's a preponderance of evidence. It's not even a criminal finding.
It's not tied to the preponderance of evidence. It's what child welfare determined.
This isn't child welfare. We're talking about APS.
We are talking about the age of culpability as determined by child welfare experts who believe that children age 11 and older can be held culpable for their actions, whereas children age 10 and younger don't have that reasoning to be held culpable.
What if they have an intellectual disability? What if it's a peer-on-peer situation?
It could be.
This is very concerning to me. Very concerning to me to give a number and not have any flexibility in that.
Okay, we'll look at that. Thank you.
So, Greg, can I just clarify?
Yeah, sure.
So, Maureen, just so I understand, I want to make sure I understand. Your concern is that not that someone 10 and younger would be excluded from the CAPS check, but that someone above the age of 10 would be included.
A minor,
A
yes.
minor, okay.
Yes. So maybe that should be in there. That's a good point. It's the fact that it's between 11 and 18 that I have a problem with.
This is Jim Tatton. So what we're talking about is someone who's doing a CAPS check an investigation and they may have been 10 or older and acted as a perpetrator? I'm trying to figure out who's this.
Yeah, the notion would be, and I was just thinking about this. So a 15-year-old that's stealing money and property from their grandmother or grandfather to sell, to buy gas money, buy whatever, is that mistreatment and abuse that would need to be logged in a if APS was called and they investigated and substantiated that the 15-year-old was in fact exploiting their grandparents, would we want to have a record of that? Or, you know, if a 15-year-old or let's say a 17-year-old knocked on a senior adult's door, they came to the door, they forced themselves way in and assaulted the older adult and stole from them.
That would be a criminal act, though.
That would be a criminal offense, but would that it would be if it was
Yeah, the example you gave was criminal, and then there would be a youth court procedure. It would not be an adult procedure. And what you're doing here is you're putting an adult label on a minor.
So in
the
the
perpetrator.
case, well, let's play this one through though. In the case of the 17-year-old knocking down, there may or may not be
a criminal
case. Right. But if reported to APS, and I think this is something we covered 1 or 2 times ago, I don't recall exactly, it is incumbent upon APS to investigate independent of, but coordinate with.
Yeah.
Okay.
Yes. And that's a good distinction, Greg, because APS is really focused on if the police do not pick it up as a criminal charge, and that can be they can not pick it up because they can't. The witness isn't credible, or it's difficult to
prove beyond a reasonable doubt.
That's right. Then would you
going to a lower
would you
standard,
capture that information that someone abused an at-risk adult, harmed an at-risk adult, even though they didn't face criminal charges? Would you want to capture that? That's the question, and that's the rationale behind this, as I understand it.
Rob?
Can I?
Oh yeah. Yes, of course.
What's this?
2 things. I see this as basically, especially if it's an IDD person themselves, getting onto the CAS registry as double jeopardy. Because you're right. Maybe that 14-year-old or 17-year-old wouldn't face the justice system and get a criminal record. But now they are still having a form of criminal record, even though they're now adults who have maybe learned better. And I just don't see that being at all a form of justice. Secondly, I actually have a client who is high functioning enough, even though she's IDP, she went and got a CNA, certified nursing assistant. Of course, she needed a lot of support and everything else, and really has not had difficulty finding and keeping a job in that field. But besides that, that was her goal. She accomplished it. What if ask somebody like her after 2018 gets into some sort of peer-on-peer, fight, or maybe bullying or something else when they're like 13, 14, is even substantiated, let's say. But now they're 25. They have learned better social skills. They get the rules a little bit better. All the independent life skill classes have taken into their being. And want to go on and become a CNA and help other people, but they're on this registry because at 14 they IDD, so they were more like mentally 10. They got on this registry. We're going to deny somebody that? Really? We wouldn't deny it to the 14-year-old. No, I'm just saying.
Yep.
This could be, you could have IDD people on this registry.
You're getting
as
head
well
nods. And,
as regular.
yeah, you're getting head nods in the room here, Elizabeth. Go ahead, Mindy.
This is Mindy Kemp for those on the phone. So, two things. Kind of drawing a little bit of a distinction here between what county APS programs are required to conduct an investigation and provide services on. So, just to clarify the point that Greg was just making is any report that comes in of mistreatment of an at-risk adult that's screened in, the county has an obligation to investigate that, and that will be recorded in CAPS. That's not something that's being sort of changed or discussed here. I think what Maureen was pointing out was then in terms of this piece about what CAPS results will be reported out, and here are the sort of 4 pieces related to that, we understand, and I'm hearing questions about this number 3, which is the age of the perpetrator, and should that potentially be changed to a different age or a different criteria for being reported out. So rather than belaboring this, because we don't have that much time left, Peg has made a note of this. We'll go back. We'll consider that as feedback for the department. And I think that that's the best that we can offer tonight.
Okay, or change the scenario of throwing teacups at grandma. So it's an adult, and that's how it got into the system. She's 14, grandma's 70. She threw a teacup at her. I'm just saying that it seems like a double jeopardy issue, and it also doesn't allow for growth of people, especially anybody who might take longer to grow.
So what if I take my hat off and just ask a question as a citizen? If I understand the reading of these, though, it's not incumbent upon the care agency to deny employment based upon whatever they read, right?
That's right.
It's simply
they can still hire.
They could still hire. Okay.
And then another aspect, this is Mindy, that they can always appeal too, and it sounds like the appeal process would factor in different things. So maybe they might do something like expunge. If no further cases opened in 2 years, or they have various options under the appeal process as well that could address something like that.
Okay. Rob?
Well, I, as a professional, have limited liability and general liability and stuff that would help pay for an appeal like that. At least I believe it would. If it was a regular lawsuit, it would. I'm not so sure about this scenario because this is going to be just for Colorado. But a person who is not, already covered by such things, such as my person I just, gave the scenario for, how would they go about paying for that?
Paying for that appeal process?
Go ahead.
Yeah, this is Peg. You don't need to have a lawyer to file an appeal. The appeal is done at the state level, and no lawyer is needed. That person can ask for an appeal and then work directly with state staff to work through that appeal.
Elizabeth, were you able to hear that okay?
Yeah, but it's not something I want to do.
Okay. Rob?
2 quick things on number 3. Peg referred to experts who have determined that age 11 is the age of culpability. I'd like to see who those experts are and their research and their viable data. That would have been helpful in this because this is a discussion. I think if you want to confirm or provide some evidence that that's occurred, I think we need to see that. And the second thing is, where in the statute of 1284 does it refer to this? Did I miss something?
So this is not in the statute? So this is
So where did this come from?
so this is part of further defining the statute. So this is a proposed rule to implement, basically, of how the statute would be implemented.
You said you had two things?
Well, that was the second thing. One, I wanted to see, and if you could get
research,
that,
thank you.
the experts, and if you could get that to me when you email me tomorrow, Mindy, because I'd like to know who they are, what their research is, because I like to talk to them and I like to read their research.
So I can't promise that I'll get that to you tomorrow,
Well,
Rob, but I'll work on it.
but soon enough. But
And are they neurotypical or are they disabled?
Yes, and because Peg referred to experts, I want to know who those experts are, and I think that's a fair question.
We'll consider the feedback for this, and we'll be presenting the final rule package to State Board, and so you're welcome to share your concerns with them there.
So will we find out who those experts are before then? Because that's a very, when you make a claim that there are experts.
Why don't we do this? We'll try to research exactly where this age determination came from, and then provide that feedback when it's available. You know, it may take us some time to exactly. And if I'm correct, Peg, some of this is modeled after child welfare, right? Child welfare rule, yeah, and their process. So we can, that's where we'll start. So that answers your second question, Rob.
Yes.
Where did it come from?
It's
It
proposed.
comes from the child welfare rules,
But not from the statute, not from 1284.
not from the statute, but from the child welfare rules that we have used to emulate this system. There are substantial differences
Yes.
Between the two systems, and we recognize that. But there are some similarities as well. So that answers that question, but we can look at exactly where that rationale came from in child welfare as well. And we'll have that available for the State Board too. They may be interested in that.
Yeah.
Jim T.
This is Jim Ted. I'm trying to think of what my message would be. I'm hearing that in certain parts of the proposed regulations that we're tied to the statute. This is the language of the statute. We're following the rule, or these rules are a reflection of the statute. We have no authority to go beyond the statute. We're not a lawmaking body. And then I have this. Where in the statute? That seems to me to be an explanation of you're not just actually developing proposed rules and regulations, you're acting as lawmakers.
This is Mindy.
It's not a criticism.
Yeah, no, that's a great point, and I think what we might be able to do at either the next State Board or when these rules are heard is actually have Ted McCombs, who's our AG rep for the State Board, explain the difference between statute and rules, and because we do seek feedback and guidance from them on things like, can we expand the definition of direct care, or can we just use what's in statute? And when it makes sense to further sort of define what a process should be that's set in statute, and when you really have to kind of stick with what's in statute. Unfortunately, I can't really articulate that well enough right now for you because we do rely on our AG counsel for that. But I think that would be a great suggestion to have them provide an overview of that for the group.
Maureen?
Well, I would actually refer back to the State Board meeting that was up in Fort Collins. That was February, right, Rob?
February
Fort
2nd.
Collins? Yeah, February 2nd, because Bernie Boucher, State Board member, extremely competent man who served our state, said that he felt like the severity levels, which are the exact same thing as this one about the kids, was emulated after child welfare rules, was an overreach of the statutory language. And he actually said it was the most uncomfortable discussion he had had since he was on the State Board, that he felt it was inappropriate for the rulemaking body to be delving into areas that were not defined in House Bill 17-1284. And here we are, we're hearing the same thing with this. Oh, it's emulated after child welfare rules, and we're further defining the statute. This is what Bernie Boucher and Ms. Tay Chanel and Ms. Rule, 3 different members on that board, okay? Now we're talking about a vote. they all said this was inappropriate. So I really think you need to consider striking that as well as the severity levels, because the board was very clear as the voting body that they were uncomfortable with overstretching.
Thank you.
Yeah, they were rather adamant
Forceful.
about it.
Yeah.
And so was the chair.
Did you record her bit about
Especially in regards to severity levels, because
We have that in the other room.
That's again. I recall that one. I'm just.
especially in regards to the severity levels, because, that's something, I know the AG, he already addressed that. He talked about that, maybe if you remember that discussion about the severity levels. And he went into great detail, so we probably don't need to discuss it again, because they've already had that civic lesson. But the problem is that it's almost like you're ensnared. We've got you, you're ensnared. Oh, we determined, we did, all it was a preponderance, which is an opinion, and nothing criminal occurred. But yet you're ensnared, and so we have to negotiate with you based on one or two, severity level 1, 2, or 3. I don't think the state board did not concur with that. No. You didn't see nodding heads in regards to that.
I wasn't at the meeting, but it sounds like they'll get a chance to review this, and
I would.
Ultimately, it's up to them to
yes, and
pass these rules, right?
I mean, be strongly vocal about striking the severity level.
So it's incumbent upon
as well as
the department to draft them.
Yes.
So the board to accept them.
I can't make a motion, but my recommendation is to strike J4, especially the part that says in severity levels of the mistreatment.
And then also the, L3, which is in regards to the 10 or younger on this scroll packet. And then I had another.
1 second, we need to capture that J4.
On page 10.
Strikes J4 on page 11 as being an overreach.
Severity levels of the mistreatment.
Maureen, you were going to pick up one other spot.
Oh yeah, it was the one about the 10 years. That was L3.
Yeah, I think we've got that.
Yeah.
Got that captured. Other areas, we've got about 12 minutes left here, so are there other spots that anybody wants to dig into? Looking at the phone and recognizing that you can't see me looking at you. Sorry. Anybody on the phone have comments on this? Okay, back to you, Maureen.
Yeah, I was just wondering, I stepped out to use the restroom and I came back in and there was a little bit talk about the appeals process, and at the last meeting we requested a timeline of like the days and the numbers and a flow chart, and I'm wondering if the department and the staff were able to put that together, because I think that'd be really helpful for us to understand that process.
Yeah, this is Mindy Kemp. So we've been working on that, and we thought it was a good suggestion. And so we understand that the due process proposed rules are very complicated, and that there's a lot of timeframes in there. And so we're working on drafting that to present to the state board at the April 6th meeting.
So it won't be available to the public before then?
It will be available when the documents to the state board are made available to the state board. I can't say exactly when it'll be posted, but we'll be making it available as we make it available to the state board.
I thought last month when we talked about it, I didn't realize that it was limited to the state board. I thought we were talking about using that as a piece for the public to comprehend Rule Packet 2 as a follow-up on our last stakeholder meeting.
Right, so it will be, since those rules haven't passed, so it's proposed, right? It's based on the proposed rules. It's not the final due process. It's the due process if the state board were to propose it. And so we're going to use it as a tool to educate the state board on if they were to accept Rule Packet 2 as it's currently stated, here's what the due process would look like. And then as a sort of a in addition to that, it will be made available to the public as part of the documents for state board.
Well, I'd really like to say, as a community activist who has gotten people involved in this process, that it would really be a sign of good faith, Mr. Wester, for the department to get that out to the public prior, because people need that information to review and understand. And I think waiting till the meeting is just another message to the actual people that live this life every day, that we are an afterthought, Everyone else was involved in this process. The people that make money off the backs of my son, the Alliance, the CCBs, they were all involved in this process from the very beginning. No one reached out to me. And I really feel like this is the one olive branch you can offer us, is to say, here's some information so that you can better understand, because there are like 10 pages of different dates. You know, it's complicated. So I would really appreciate that, and I think it would be a great gesture to the community to say, we're trying to help you understand this. So,
Maureen, what I was saying is that we are working on finalizing that this week. If we have it available before April 6th, it will be available to you as well as the state board members. I don't want to send it out before it's finalized and been cleared through folks in our department so that it's accurate. And I would rather wait until we have a final draft that is accurate. So if we have it before then, you will absolutely get it. We'll get it as soon as the state board members get it. That most likely will be by the end of this week, but I'm not going to make any promises because I want to make sure it's accurate before I get it
I've been waiting 2 weeks for it since our last meeting, so I was really hoping that it would be available today, that's all. It was a request we made 2 weeks ago, so. And I'm not saying it needs to be a pretty PowerPoint, you know, just the dates in a chart. I don't need to have it be a graphic artist final report. But it's just, it's a messaging, it's outreach to the community. And I feel like this rule package, it's intimidating to most people.
Absolutely.
And I think that part of the stakeholder process is making the materials easier to understand. That's all.
Okay, just so you know, and I appreciate the feedback, a couple of things. One, the rule packet on due process is a public document. It has been submitted to the state board, and it's in narrative form. I mean, it's in the format of rule. So any spreadsheet or flowchart or PowerPoint would be a supplement and reflect exactly that document first. Okay, so it is public. Secondly, in the process of any documents that, like when we send the rule packet again with the revisions that the stakeholder process has brought about, when we submit those to the state board, we load those up, and then it is submitted to the state board. At that point, I believe, and I'll have to confirm this, but I believe at that point it becomes public, right? And so that's why there's a very formal process for us to make sure that those documents, including this, you know, description and portrayal of the due process, we want to make sure it's right. And it's a formal process that we go through. So that's what Mindy is saying, is when it's available to the state board as a public document, it will be available to anyone that wants it.
Well, I'm just asking it as an accommodation for understanding for public that may not have a college education. Okay, you have to have a college education to read this, Mr. Wester. And most of the families that I work with don't have a high school, they don't have a high school diploma, a lot of them. So this is about reaching out to the stakeholders, and HIPCUF has created many supplemental documents when we've requested for the community. And I don't understand why a department that has human in the name can't do that for the community.
We are doing that.
No, you told me that I won't have it until the state board, and we asked for it 2 weeks ago.
I think what he said is he's committed to getting it right.
Back up, because that's not what I said, Maureen. I said that when we submit the documents to the state board, which is prior to the state board meeting, they will be public. Okay, and that's when you will get them. You'll have them in advance of the state board.
Okay.
And I'm sorry, apparently I wasn't clear about what our process is, but usually the state board gets the documents in advance of the state board meeting so that they can review and be prepared when they come in.
I understand that process. I guess I was under the impression when I requested it last week, I wasn't asking for the entire presentation to the state board. I was asking for one piece of visual information.
We're finalizing that document.
Right.
Yes.
So it's morphed into something bigger than I requested. I requested just a due process piece of paper, and now it's an entire presentation to the state board. So I think that we're talking two different things.
I'm saying.
Okay.
Okay. What I'm saying is we're finalizing the document that that outlines due process.
And the document, Mark, for clarity, is a graphical representation of the steps, ownership, and timeline.
which is part of the APS presentation to the state board. Correct?
No, it's
No,
a supplement to
necessarily.
the due process rules.
Okay.
Okay. 3 minutes, 4 minutes left. Rob.
On page 9, letter E, where it talks about using the form, blah, 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 et cetera, to written authorization for the new or existing employee prior to requesting a CAPS check. The employee shall, this is confusing, also provided the employer any required identifying information necessary to request the CAPS check. Some employers can say, oh, I need to see your social security number. And what if they say, well, I'm not going to give it to you, I don't have to. Sorry, you can't work here. So that needs, identifying information needs to be defined more clearly.
That's
Is my reading of that. Okay.
Appreciate that, Rob.
It's just not clear because you're going to have 400 different ways of it being interpreted, unless it's clear.
Yeah, and if I could, again, take my facilitator hat, put my citizen hat on, I think that is part of the roadshow and the, understanding how to create a positive match versus, John Q. Smith of recently of this address. I mean, there are ways that is done, but I must say I don't know what they are, but I know that would have to be a critical part of making sure that you were having the right individual without a unique identifier like a driver's license or social security. Okay, facilitator hat back on. Any last thoughts? I'm going to go to the phone first. Anybody on the phone have any last minute comments?
I actually had a question because if it comes back substantiated, is there going to be any details? Like, oh, well, when she was 14, she stole $500 from her grandmother. Or when they, last week, at their old job, they beat up an old man.
Mm-hmm.
Two very different things. I understand we're trying to severity level, but is there going to be anything that would allow me to make a judgment call?
Yeah, so this is section J. That was at the top of page, make sure I got that, I'm sorry. About the middle of page 10, it reads, the CAPS check result shall indicate, 1, whether there is or is not substantiated finding for the new or existing employee, 2, the purposes for which the information in CAPS may be made available, 3, the consequences of improper release of information in CAPS, and 4, for CAPS checks in which there is a substantiated finding, the CAPS checks results will include the date of the report, county department that completed the investigation, and the types and severity of the mistreatment. So that's, Elizabeth, how it reads.
This is PEG, and the mistreatment is either going to show as physical abuse, sexual abuse, or exploitation. And the severity level will be either minor, moderate, or severe. And the definitions of those severity levels would be included in the response back to the employer.
Thank you.
Caretaker neglect as an option.
Oh, caretaker neglect, yes, sorry.
As another example, okay. So, Elizabeth, answer your question okay?
Yes.
Anybody else on the phone have any last minute thoughts?
I just want to thank you guys for taking the time today and the folks who came out.
Thank you.
Thanks for sharing.
And before we close, I just want to point out that severity levels are not in the statute, not in House Bill 17-1284. I think it's important to know that, note that, and put it on the record.
And also that the severity levels can be negotiated. So they may have had a severe or critical or whatever, I forget the levels, the top one, the most severe, and they may have negotiated it down through the process, which is similar to child welfare and is not in House Bill 17-1284. So it's really not reflective of, it's reflective of what was negotiated, not what actually happened.
Yeah, this is beyond the scope of the bill.
Okay. Maureen, did you have a last?
Yeah, I guess I'm just, just to wrap it up, to take it back up to 50,000 feet. And I'm actually thinking about, I'm sorry, I forgot your name with the ombudsman. Yes, my father was in, because I think we talk a lot about the IBD because of the people who happen to show up at these meetings, but I'm also thinking about the elders in our community and living independently and promoting in-home services and trying to make sure that we're maximizing life. And I'm really concerned that this whole APS philosophy is going to take independent living back 50 years. And people are going to feel pushed into nursing home and more restricted settings for elders as well as people with intellectual disabilities. And I have some concerns around personal choice and the dignity to risk. The dignity to risk. All right, my father lived in, and forgive me, Father, he's up in heaven right now, but my father lived in a senior living, and he was one of the few men there. So, of course, the women were all very interested in him. He was widowed for 15 years, and a couple women invited him into their apartments, you know, and he got in trouble for that. And it was his own apartment. All right, so are those going to be perpetrated, substantiated people? What about my 20-year-old students at Aurora Public Schools that I taught? We did sex education with them. They had a Planned Parenthood class after school hours to teach about consent. You know, what it is to be in a relationship. Every time someone is in a relationship with someone who's considered at risk, no one's going to have the freedom to even have their own personal relationships. I'm really concerned about this community living and the fear that will limit life choices. And I think it's broader than IDD. I think it goes into elders. I think it goes into brain injury. And I want my son to live a full, rich life in the community. I want him to work. I want him to get around town on his own. I want him to have personal relationships and even get married if that's what he chooses to do. But if we have all these rules and we're saying, oh, that's substantiated, that's not, that's caretaker neglect, he's never going to learn to live on his own. And that's my biggest problem with this bill. And I know it's not Rule Packet 3, but it comes back to the civil rights piece. And I'm curious what, as an ombudsman, you know, how you view that overall restriction of choice and civil rights.
This is Ann, State Long-Term Care Ombudsman, and I have appreciated being here for these 3 meetings. I'll try to make sure I speak loud enough for the phone. I feel like what I'm experiencing is the tension as an advocate because they're countervailing forces. You want the right to risk and the dignity of the risk. I also very much want people protected from harm. And in a complaint resolution world, you hear a lot about the harm, like real harm that has happened. And I've also heard some good feedback about, you know, can we make this transparent flow chart? I have asked for flow charts from other departments trying to understand regulatory processes and enforcement processes. So I'm friendly to that. I have to say I fall on the side of we're kind of behind most other states. I love that we're holding the tension of the discussion, but I really feel like we've got to move forward with this because the greater good is this document moving forward and tweaking as we learn things as opposed to blocking everything and losing the good. And again, that comes from the desk of someone that hears a lot of complaints, sees a lot of substantiated harm, particularly in the world of elders and long-term care. Less about community, more about people who live in facilities where there's frankly more oversight and more support. I worry a lot about the vulnerable elder in the community, unable to make their needs known, unable to express concerns or fears about things that have happened or could happen. I don't think there's an absolutist, you do this, not that. I think what we have to do is this difficult and intensive process ongoingly.
And have you looked at other states? Do they include the IDD in that at-risk population, or is it more? Are you speaking specifically to elders and long-term care?
Really, truly, I need to stay in my wheelhouse of elders and long-term care.
Okay.
So IDD has limited experience for you.
It's certainly in the world of APS, yes. Not in my personal world,
Yeah, I
no.
just wanted to make sure I understand it.
Right. Long-term care ombudsman. But not in my personal world. Plenty at home.
Thanks, Ann. All right, so where do we go from here? CDHS will take the feedback received from this stakeholder meeting and the other two, and we'll consider along with the stakeholder feedback they've received from the advocates in the industry and the PACs and the sub-PACs and all of the different groups who are engaged in the rulemaking process. And we'll submit a final draft proposed rule language to the State Board of Human Services. Rule Packet 2 will go for its reading on April 6th, and Rule Packet 3 is planned for a reading on May 4th. Okay. So appreciate everyone's attendance. Appreciate your active participation. I think there were some very valuable pieces of feedback for consideration, and you proved the importance of doing this. So thank you.
Take some cookies.
Yeah. All right. We're going to sign off on the phone. Thanks.